my background here is around disability perspectives in a proposed constitution. So what I did is I got the students, the Equity Justice Project students, who are just a fantastic team of people, I got them to do some background for me, and some of that background was that I wanted to know what happens internationally around social justice. I looked at the broader sense of social justice, and then I asked them which constitutions bring in disability. And I was surprised, was and was not. It's quite ironic that Ecuador is quite pedantic around the detailing of how it incorporates disability, and yet they can't look after their indigenous. But then there are other countries that surprise me. We've looked at the USA, we looked at Ecuador, Venezuela, the European Union, and we looked at Israel, which has an early history of including disability, and yet they can't look after their Palestinians very well. So it's quite interesting how you'll get one contrast against another. But we had a look through a range of different countries, and then we looked at the New Zealand place as it stands now with the 1986 Constitution Act, but where disabled sit within that, and where disabled sit within New Zealand law. And then we looked at the UN Convention on the Rights of Persons with Disabilities, and then they gave a set of recommendations. It's all there in a draft, and I'm happy to get that out to you. But there are a couple of thoughts that came through, and in fact it helped immensely having, Paul Rishworth, one of my favourite speakers. I love listening to him when I'm on the Human Rights Review Tribunal. Fantastic lawyer, and several others there that were speaking, Wayne speaking this morning, and just before, having those conversations were just fantastic, because it starts to form our own mind on where we want to place ourselves. And so we've found that we've got the convention signed, we've had it ratified, but the optional protocols haven't been done. And then we find that there's been an absolute abuse of process just recently from the 17th of May budget, where the Public Health and Disability Amendment Bill became law, without any form of calling for submissions, without any public consultation, and specifically have introduced in there a section, a brand new piece to it, new section 70E, provides that no complaint may be made to the Human Rights Commission, and no proceedings may be commenced or continued in any court if the complaint is, in whole or in part, based on an assertion that a person's right to freedom from discrimination on any of the grounds of marital status, because spouses were excluded from the whānau paid as carers bill, marital status, disability, age, because parents of children under 18 with disabilities were excluded, or family status, children looking after their adult parents, all these other ranges were excluded. Affirmed by Section 19 of the Bill of Rights Act 1990, has been breached by a provision of the bill, or by family care policy, or by anything done or omitted in compliance, or intended compliance with the bill or a family care policy. Such an assertion is called a specified allegation in new Section 70E. New Section 70E stops the Human Rights Commission from dealing with complaints based on a specific allegation if the complaints were made after the 15th of May 2013. It also stops the Human Rights Review Tribunal that I sit on, and any court from hearing or continuing to hear or determining any civil proceedings that arise out of, I've lost my place there, civil proceedings that arise out of such a complaint made after 15 May. We had to know about this, so we should have made it before 2013. Complaints made to the Human Rights Commission before 16th of May are not affected, and the Human Rights Review Tribunal and courts continue to have jurisdiction to hear and determine proceedings that arise out of complaints made before that date. However, if such a permitted proceeding is successful, the Human Rights Review Tribunal or the court may only grant a declaration that the policy concerned is inconsistent with the right of freedom from discrimination, affirmed by Section 19 of the Bill of Rights Act 1990. New Section 70F authorises it to, it carries on. But essentially, the bird, give women with one hand under the Bill of Rights Act has just been removed for one group of people under the new Section 70E of the Public Health and Disability Amendment Act. And so, for us, if we're looking at a constitution, then we need to be thinking seriously, as there have been the arguments, do we want an entrenched Bill of Rights Act where they cannot remove the rights of our citizens? Or do we want to leave it up to the Parliament to make its own decisions at times? You know, and the inconsistencies are a little bit scary for me. However, you know, it is a discussion that we need to be having, and we have not had enough of that. I do know of a group putting together a petition that is going to go to Parliament in about September to further argue this point and make note that we are not happy with this. And no, disabled persons aren't happy, because not only did Parliament ignore its own Attorney General, Chris Finlayson, who said that it was inconsistent with the Bill of Rights Act, they chose to ignore our whole community. They chose to ignore our so-called consultations that took place. They chose to ignore a large part of, you know, what we had said in the community. So we won our legislation. We won through the courts on one hand. We won the right for whānau to be paid as carers. However, we lost in that spouses cannot be paid as carers. We lost in that parents of children under the age of 18 who are severely disabled cannot be paid as carers. We lost in that the adult children cannot care for the elderly. We lost in many regards. And also only paid minimum wage when many of us are already paying our support people living wage. So there's a whole bunch of issues here that stand, and this was a perfect example of why within the Constitution we may want to look at having it a lot stronger. So I want to open up the discussion really, because I don't want to be in charge of this whole discussion. It's in the paper here, some of the draft stuff that the students wrote. However, there are pieces there that aren't strong enough, so we need to strengthen the arguments. And I'll take that on board too, Nicola, around the brief discussion we had last night. I take on board that we need to be looking at extending the argument around this legislation as being a great example of where we're not going right and where we need to have some protections, particularly protections of groups that aren't reflected in Parliament at a great degree. We had our first openly or known about disabled person in Parliament as late as 2011, and that was of course Mojo. Fantastic to have her in there. However, they also couldn't get that part right because they wanted to argue the point that that there was going to be issues with the fact that she was deaf and needed support. So, we've still got a long way to go before society embraces us, accepts us, or understands what our needs are. So we need to be very strong on the statements we're going to make around the constitutional review.